Afternoon, everyone. Welcome to the Environmental Law Institute's monthly climate change briefing for the month of October. I'm Madison Calhoun, ELI's educational programming attorney. As a special service to the public, ELI provides a series of monthly webinars with national experts on climate law and policy to keep you up to date on those topics. On behalf of ELI, I want to thank you for joining us for today's program. I also want to take a moment to thank our speakers. We so appreciate that they have each taken the time with their busy schedules to prepare these informative updates. We have a great program in store for you today with 3 speakers this month. Our speakers will take questions from the audience as time permits, so please post your questions in Zoom's Q&A box throughout the event. You do not need to wait until the end of the program to submit your questions. Please enter them into the Q&A box as soon as you think of them. Today's webinar will be recorded for ELI members to view later. The recording will be posted on the event webpage within a few business days, so just be sure that you're logged into your ELI account in order to watch it. If you're not an ELI member, please consider joining us. We will drop a link to the membership page in the chat for you to check out. I will now go ahead and turn things over to our first speaker today, Michael Gerard, the founder and faculty director of the Sabin Center for Climate Change Law at Columbia Law School, for a litigation update. Over to you, Michael. Thank you so much.
Thanks, Madison. A lot of decisions in the last month. So the federal district court in Montana dismissed a suit by youth plaintiffs seeking to annul 3 of President Trump's energy-related executive orders. The court agreed with the plaintiffs that the orders could worsen climate change and that the plaintiffs had established injury in fact as a basis for standing, but the district court concluded that the Ninth Circuit's decision in Juliana versus U.S. foreclosed the existence of the redressability element of standing. The district court found that it was unlikely that a declaration of the executive order's illegality would redress the plaintiff's claims by, quote, reverting the entirety of the United States energy policy back to January 19th, the day before President Trump took office. The court concluded that plaintiffs' compelling case for redress must be made to the political branches or the electorate. That case is called Lighthiser versus Trump, and the plaintiffs have just filed a notice of appeal with the Ninth Circuit. The D.C. Circuit denied the Sierra Club's petitions for review challenging FERC's environmental review and authorization for a natural gas pipeline that would feed a natural gas turbine replacement for a coal-fired TVA power plant. The court said that in view of the Supreme Court's May 2025 decision in 7-County Infrastructure Coalition versus Eagle County, FERC's decisions about the proper scope of environmental review were entitled to great deference. The court found that FERC did not err by not analyzing the pipeline and power plant together as connected actions. The court concluded that after 7-County, agencies are no longer required to analyze the impacts of actions, in this case the power plant, over which they do not exercise regulatory authority. In contrast, a state court in Louisiana vacated a coastal use permit granted by the State Department of Energy and Natural Resources Office of Coastal Management for an LNG export terminal in Cameron Parish. The court found that the agency failed to consider the facility's secondary and cumulative impacts related to climate change. The court also found that the state agency failed to consider the environmental justice impacts of the project. That was Sierra Club versus Louisiana Department of Energy and Natural Resources. New York City is suing several fossil fuel companies alleging they violated the city's consumer protection law by misleading consumers about the climate change risks of their products and their commitments to renewable and alternative energy sources. In a 2-to-1 decision, the Second Circuit found that the district court did not abuse its discretion when it ordered the companies to pay New York City for attorney's fees and costs related to the company's removal of the case to federal court. The Second Circuit majority concluded that there were so many court decisions barring the removal of such cases to federal court that it was objectively unreasonable for the companies to attempt to remove the cases. The dissenting judge concluded that a party that uses a local consumer protection law to combat global climate change should not be compensated on the premise that the other side is filing frivolous papers, close quote. And Exxon has just indicated that they're seeking an en banc review of that decision. The Federal District Court for the District of Columbia denied a motion by environmental organizations for a preliminary injunction blocking the Export-Import Bank of the U.S. from dispersing funds for an LNG project in Mozambique. The suit alleged that the agency violated the Export-Import Bank Act of 1945 and its own procedures and NEPA. The Federal District Court for the Western District of Louisiana declared that President Biden's January 2025 withdrawals of certain areas from the Outer Continental Shelf from potential oil and gas leasing were unlawful because they exceeded his authority under the Outer Continental Shelf Lands Act, which authorizes the president to withdraw unleased lands from disposition. The court found that such withdrawals do not bind future presidents. The Federal District Court in Puerto Rico ruled that FEMA should have prepared an environmental impact statement for the provision of funding to restore utilities damaged by Hurricanes Irma and Maria in Puerto Rico. The plaintiffs, who are community and environmental groups, challenged the charge that the defendants violated NEPA by, among other things, failing to consider distributed renewable energy alternatives and failing to adequately examine environmental harms associated with the rebuilding of the fossil fuel grid. In another case from Puerto Rico, the Federal District Court dismissed claims from the municipality of San Juan asserting that fossil fuel industry defendants concealed the relationship between their products and catastrophic weather phenomena, such as the 2017 hurricanes. The court rejected San Juan's efforts to distinguish its case from the case brought by other Puerto Rico municipalities, which a sister court in the District of Puerto Rico dismissed on September 11, 2025. That decision is now under appeal. Finally, 8 months ago, the Federal District Court found that American Airlines and its Employee Benefits Committee breached their fiduciary duty of loyalty under ERISA by allowing corporate interests in environmental, social, and governance objectives and their investment managers' ESG interests to influence their management of employee retirement funds. The court has now denied the plaintiff's request for monetary damages, but it determined that it was necessary to award equitable relief, quote, to ensure that defendants and their investment managers act solely for the pecuniary benefit of their retirement plans and implement compliance measures to ensure fidelity to ERISA's fiduciary standards, close quote. The court permanently enjoined the defendants from permitting, quote, any proxy voting, shareholder proposals, or other stewardship activities on behalf of the plan that are motivated by or directed towards non-pecuniary ends, including but not limited to ESG-oriented investment management and objectives that are not in the exclusive best financial interest of plan participants and beneficiaries, close quote. The court imposed various monitoring and reporting requirements on the pension fund. That case is Spence versus American Airlines, and that's my litigation report.
Thank you so much for those great updates, Michael. Up next, we have Dan Farber, the Shosedo Professor of Law at the University of California, Berkeley, who will be providing updates from several states. Over to you, Dan. Thank you so much.
Great, thank you. Actually, it doesn't seem to have been a very active month in the state legislatures, at least in terms of legislative output. But there are some significant developments to report. Starting in California, Governor Newsom signed a package of climate and clean energy laws that had passed the legislature last month. Most notably are two laws. AB 825 authorizes CAISO, the state's grid operator, to collaborate with utilities and regulators in neighboring states to create a regional day-ahead electricity market. This will create more opportunities for California renewable generators to export power, while also allowing more opportunities for California to import power from renewables from other states. This complements the current, or I guess I should now say prior, energy imbalance spot market for power that had included several states. This has been seen as a step toward creation of a regional power market that could make the energy transition much more economically attainable, both in California and in some other states. Another law, AB 1207, extends the emission trading system in California, which was called Cap and Trade, but is now called Cap and Invest, until 2045, in line with California's long-range emission reduction targets. The Cap and Invest nomenclature, I think, is in recognition of the fact that the system has already generated several $billion for California, which has been plowed into climate-related investments in infrastructure and programs. And the goal is to continue this on a broader scale. By extending the length of the trading system and the planning horizon, the legislature was attempting to provide a greater long-term stability legally, and thereby to encourage more investment in clean infrastructure. Newsom disappointed clean energy advocates, however, by vetoing several bills that were also intended to further the expansion of clean energy. The vetoes were largely based on the ground that these bills would put too much of a burden on overstretched regulatory agencies and detract from their ability to accomplish other work. Climate advocates were also unhappy with the bill allowing expanded oil drilling in California, which Newsom signed as a compromise energy affordability measure. A couple of key takeaways. One is that California seems undaunted by attacks on its policies from Trump and the Republican Congress. If anything, California is doubling down on its commitment to climate action. It will be interesting to see whether the administration escalates its own attacks on these programs as a result, which could clearly result in more litigation for Michael to report in later meetings. It will also be interesting to see how much of this is a California phenomenon and how much it is mirrored by other states, such as Massachusetts, New York, or Washington State. The other takeaway is the increased concern over energy affordability. As we'll see below in a couple minutes, well, actually in probably only 1 or 2 minutes, this is a broad concern nationally. Energy costs are being pushed up, among other things, by diversion of natural gas to export in the form of liquefied natural gas, and to the rush to try to meet expected demand from data centers due to the AI transformation. And I think after the last election, affordability matters in general are a higher priority for politicians, and we're already starting to see complaints from ratepayers about recent changes in power prices. So as an example of that, there's Delaware. The Delaware utility regulator blocked what it calls large load consumers, like data centers, from connecting to the grid until the utility submits and the regulator approves a new higher electricity rate for them. That means that the costs of the increased transmission and distribution costs relating to these new sources will not be spread among all ratepayers, but will be heavily concentrated on the new data centers and other large load consumers. In Louisiana, the utility regulator approved new rules that will increase investor-owned utilities' annual spending on efficiency programs by about 50% in 2026 and double it by 2030. The Louisiana Energy Efficiency Program rules include a mandatory low-income program directing at least 15% of funds to low-income households. Energy efficiency has generally not been a priority in southern states, so this development in Louisiana will be significant and possibly a sign of similar actions elsewhere. We'll have to wait and see about that, obviously. Like Delaware, Ohio's utility regulator is addressing electricity rates for data centers. Data centers with loads greater than 25 megawatts must pay at least 85% of their highest previous monthly electricity use, even if they use less, to cover associated infrastructure costs. The order also establishes a 4-year load ramp period, gradually forcing data centers to pay an increasing portion of the maximum capacity they contracted for, regardless of their actual use. So the idea here, as in Delaware, is to try to shift infrastructure expenses relating to additional transmission to the data centers themselves, rather than allowing it to be spread more widely among ratepayers. In Rhode Island, Governor Dan McKee announced that $10 million in Regional Greenhouse Gas Initiative proceeds will fund Clean Heat RI, a program that helps low and moderate income households transition to electric heat pumps. And then finally, Wisconsin and Hawaii became the latest states to join the Affordable Clean Cars Coalition, bringing membership in the coalition to 13 states. The coalition, formed in May 2025 in response to federal rollbacks, collaborates on policies and programs to deploy affordable clean vehicles and reduce transportation emissions. The congressional veto of the California Vehicle Preemption Waiver and the rollback of IRA provisions dealing with EVs will clearly be making it more difficult for states to achieve their goals in terms of emissions reductions. That may also imperil their ability to comply with air quality standards under the Clean Air Act, since many of the state implementation plans were premised on reductions in automobile and truck pollution due to EV uptake. If that's not going to happen, states are going to have to find other ways to meet their air quality goals, which probably means clamping down further on industry. If cars are going to maintain their EV trajectories as planned, they're going to have to find creative responses because of the congressional veto that I mentioned earlier, the IRA provisions, and then various efforts by the Trump administration to snarl up other sorts of funding possibilities. So that's going to be a major issue for state governments over at least the next few years in trying to achieve their emission reduction goals. And with all of that, let me turn it back over to Madison. Thank you.
Thank you so much, Dan. Last but not least, Bob Sussman, Principal at Sussman and Associates, will be continuing the energy discussion with an update on clean energy grants, as well as updates on climate speeches at the UN Assembly and the endangerment findings. So over to you, Bob. Thank you so much.
Yeah, thanks, Madison. Good to be here. I wanted to begin with an international focus and comment on the recent United Nations General Assembly meeting in New York in late September, where climate change was a prominent topic. First, our president was there, and in his September 23rd speech to the UN, President Trump called climate change the greatest con job ever perpetuated on the world. He urged other nations to abandon carbon reduction goals and expand use of traditional fossil fuel energy, saying that they should, quote, get away from this green scam, or else your country is going to fail, close quote. Trump also called renewables a joke that don't work, saying they are too expensive and not strong enough to fire up the plants that you need to make your country great. He added that the wind doesn't blow, the big windmills are so pathetic and so bad, so expensive to operate, and they have to be rebuilt all the time. They start to rust and rot, most expensive energy ever conceived. The UN meeting also featured a contrasting speech the next day by China's President Xi that affirmed support for climate action and the Paris Agreement, from which the US has withdrawn, as we all know. Announcing China's new national commitment under the agreement, President Xi said that, quote, China will by 2035 reduce economy-wide net greenhouse gas emissions by 7 to 10% from peak levels. Although there was some disappointment that China's goal was not more ambitious, observers did note that this was the first time China has formally defined an economy-wide emissions reduction target. Xi also announced new goals to increase renewable energy, including expanding installed wind and solar power capacity to over 6 times 2020 levels and increasing the share of non-fossil fuels in total energy consumption to over 30%. Turning back to Washington, D.C., on September 7th, the National Academy of Sciences released its report on the current state. Hold on just a second. The current state of climate science since EPA's 2009 endangerment finding. The report was prompted by the Trump EPA's proposal to repeal the finding, and it found, contrary to the report commissioned by the Department of Energy, that the science supporting the 2009 finding that the human-caused emissions of greenhouse gases threaten human health and welfare was accurate, has stood the test of time, and is now reinforced by even stronger evidence. The National Academy of Sciences is pretty authoritative when it digs into a major scientific issue. And this report is reinforcing the perception of many observers that EPA's final rule repealing the finding will have to rely on a legal rationale rather than a blanket rejection of the science on which the endangerment finding was based. Let me turn to the federal government shutdown, which began on October 1st, which has been accompanied by additional cancellations of grants for clean energy and related projects. On October 2nd, the administration announced that the Department of Energy is terminating $7.5 billion in grant awards supporting 223 projects. The projects cover a wide range of sectors, including power, biofuel, hydrogen, solar, cement, carbon capture and storage, and mining and transportation. The administration said that the cancellations were aimed at states that voted for Democrats in the 2024 presidential election and were intended to punish Democrats for the federal government shutdown. However, despite the Democratic state focus, the cancellations were also slated to occur in 7 states that voted for Donald Trump in 2024. Subsequently, media reports have indicated that DOE is considering cancellation of hundreds of additional low-carbon energy projects representing nearly $24 billion in funding, including grant awards for hydrogen hubs, carbon capture and storage, and advanced battery manufacturing. Meanwhile, the Department of Interior has continued to pull the plug on permits for offshore wind and solar projects. The latest project to bite the dust was a massive solar array in Nevada expected to power hundreds of thousands of homes. The limitations the Trump administration has placed on the expansion of new renewable power are occurring as we just heard, against the backdrop of skyrocketing electricity rates, which the president, in fact, promised to cut in half during the 24 campaign and his first weeks in office. Democrats are arguing that wind and solar offer significant benefits in rapidly expanding electricity supply and lowering energy costs and should be excluded from the power mix. This is a politically and should not be excluded from the power mix. This is a politically potent issue that will only get more visible in coming months, and we'll all be hearing more about over the next year. And that's my report.
Thank you so much, Bob. This brings our monthly climate change briefing for October to a close, as I see we are 1 minute over. Thank you again to our wonderful speakers for taking the time and energy to join us today. Please join us next month on November 18th for another briefing. We dropped the link to the registration for that in the chat. Programs like these are made possible with the support of ELI members. If you are not already a member, please consider joining us. Members can attend exclusive member webinars such as our PFAS briefings. They also have access to many other benefits, including our webinar archive, our weekly newsletter containing environmental alerts and job postings, our claims publications, and so much more. You can find out more about membership at eli.org. Thank you all so much, and we hope you have a great day. We'll see you in November.